2 hours ago. That's it. 2 hours. Trump defied a binding federal ceasefire order and bombed Iran again for the second time, and a federal judge just issued an immediate arrest warrant in response. This is where we are right now. Federal Judge Patricia Delgado issued an immediate arrest warrant for President Trump. Case number 2, 6CR4471, filed at 3:18 p.m. Eastern. Not a hearing notice. Not a contempt finding with a future court date. An arrest warrant. Signed, sealed, enforceable right now. The reason. Confirmed reports that Trump authorized a second round of airstrikes on Iranian soil in a zone covered by a binding federal court ceasefire order. A ceasefire his own legal team agreed to, in writing, filed with the court. Civilians are dead, the ceasefire is in pieces, and a federal judge just decided she's done asking. This is not a political disagreement. This is not a policy debate between hawks and doves. This is a sitting president who defied a binding federal court order. People died because of that defiance. And now a federal judge has put her name on an arrest warrant. Most coverage right now is treating this like another political attack, another round of legal drama, another headline that fades in 48 hours. It's not. This is the moment the American legal system finds out if it actually works against a president who ignores it. I'm going to show you how a ceasefire became a bombing, how bombing Iran became contempt of court, how contempt of court became an arrest warrant signed by a judge who clearly decided waiting wasn't an option anymore. 3 violations, 1 judge, 0 patience. Let me show you how we got here. Rewind. May 14th. Before any of this made headlines. A coalition of international humanitarian organizations filed an emergency petition in federal court requesting an injunction against U.S. military operations in the designated conflict zone inside Iran, standard legal process. Happens in federal courts. The case landed on Judge Delgado's docket. May 19th, Judge Delgado issued the injunction. Not a recommendation, not a diplomatic suggestion. A federal court order carrying the full force of law. Case docket 26CV3205. The terms were specific. No offensive military action in the designated zone inside Iran. Full compliance within 48 hours. Immediate notification to the court if operational conditions changed. Any violation subject to immediate contempt proceedings. Here's what matters. Trump's legal team didn't fight it. They could have challenged the injunction. They could have argued the court lacked jurisdiction over military operations. They could have appealed. They didn't. They signed on to compliance. White House counsel filed a formal acknowledgement with the court on May 21st stating the administration would abide by the terms of the order. That's not ambiguous. That's not a gray area lawyers can argue about later. That's a legal team representing the president saying, in writing, filed with a federal court, we agree to comply with this order. The injunction had teeth. Violation meant automatic contempt referral. Contempt meant enforcement. Judge Delgado built consequences directly into the order because she anticipated exactly what happened next. She wrote the enforcement mechanism before the violation even occurred. She was prepared. The terms were clear. The agreement was signed. What happened next was a choice. May 27th, 9 days after the injunction was signed. 6 days after Trump's own legal team filed compliance acknowledgement with the court. 2:14 a.m. local time. U.S. military assets struck a logistics compound inside the designated ceasefire zone in Iran. Satellite confirmation within hours. Strike damage visible. Structures leveled. The compound was operational. People were inside. The White House response came at 7:43 a.m. Eastern. Not an acknowledgement, not an explanation to the court. A press briefing. Pentagon spokesperson called it a defensive repositioning action in response to emerging threat intelligence. Defensive repositioning, not an offensive strike, not a violation, a repositioning. They didn't deny the strike happened. They redefined what it was. Here's what the court filings actually show. Judge Delgado received military activity reports from DoD liaison at 4:30 a.m. Those reports describe the action as an airstrike on a fixed compound. Not repositioning, not defensive, an airstrike. The White House told the press one thing. The military's own documentation said something different. Judge Delgado's response came the same day. Formal warning issued at 1:15 p.m. Demand for written explanation from White House counsel within 24 hours. Tightened compliance terms. Added mandatory 1-2 hour pre-notification requirement for any military activity within 200 miles of the ceasefire zone in Iran. Trump's legal team responded, not with compliance, not with an apology, with a motion to redefine the scope of the ceasefire. They argued the injunction applied only to offensive operations and that defensive actions were outside the order's jurisdiction. They didn't deny the strike, they argued it didn't count. That motion told Judge Delgado exactly who she was dealing with. The first violation wasn't accidental. It wasn't a miscommunication between the Pentagon and the White House. It was a test. Can we do this and get away with it? And the response to the judge's warning wasn't contrition, it was lawyering, not we won't do it again. But redefine the rules, so what we did wasn't a violation. The fence had been tested, and nobody got punished. June 4th, 8 days after the first strike, 8 days after Judge Delgado's formal warning, 8 days after she told the White House in writing that further violations would result in immediate enforcement action, he did it again. 3:47 a.m. local time. Multiple airstrikes across 3 separate targets inside the ceasefire zone in Iran. Not one compound this time, 3 locations. Pentagon confirmed the strikes by 6 a.m. This wasn't defensive repositioning. This was a coordinated military operation inside Iran, in a zone covered by a federal court order that the president's own lawyers agreed to respect. This one was different. Casualty reports started coming in by mid-morning, civilian infrastructure hit, aid workers on the ground confirmed 14 dead, including 3 children, footage circulated within hours. This wasn't something you could redefine with a press briefing. This wasn't something a Pentagon spokesperson could reframe with careful language. People were dead. The images were everywhere. Congressional reaction was immediate. Statements from both sides of the aisle within hours. International condemnation from 4 allied governments by noon. UN Secretary General issued a formal statement by 2 p.m. Trump's legal team filed an emergency motion attempting to argue operational necessity. The court rejected it before the ink dried. Judge Delgado didn't issue a second warning. She didn't schedule a hearing for next week. She didn't give White House counsel another 2 4-hour window to explain. She convened an emergency session at 11 a.m. that same morning. 3 hours. Sealed courtroom. 4 DOJ attorneys present. 1 warning. She gave 1 warning. And Trump used that warning as permission to escalate. Not a legal miscalculation, not a miscommunication, contempt, not just the legal definition, the plain English meaning. He held the court in contempt before the court held him in contempt. By 2 p.m. on June 4th, Judge Delgado was back in her chambers, drafting. And everyone in Washington knew what was coming. 3:18 p.m. June 4th, 2 hours after the emergency session ended, Judge Delgado filed the order. Not a contempt finding with a hearing date 6 weeks from now. Not a fine. Not a strongly worded opinion that reads well in legal journals and does nothing on the ground. An arrest warrant, case number 26CR4471, immediate, enforceable. Signed by Judge Patricia Delgado herself. The order runs 47 pages. I went through every one. Here's what she did. She didn't just rule, she built a fortress. Every constitutional objection the White House could raise was pre-addressed in the text. Presidential immunity? Addressed on page 12. She cited the enforcement framework from the contempt powers doctrine and distinguished between political immunity and criminal defiance of court orders. Separation of powers? Page 19. She argued the president's compliance agreement waived jurisdictional objections. Commander-in-chief authority? Page 23. She cited the binding nature of judicial injunctions even over military decisions when the executive voluntarily submitted to the court's authority. She wrote this knowing it would be challenged within the hour. She wrote it to survive appeal. Every argument Trump's legal team could make was already answered in the document they'd be challenging. She didn't leave gaps. She didn't leave room for interpretation. She closed every door before they could reach it. And while all of this is unfolding, while a federal judge is issuing arrest warrants and the White House is scrambling and nobody in Washington knows what happens next, most people watching this are dealing with their own reality. Groceries cost more, gas costs more, everything costs more. And the people making decisions in Washington aren't thinking about your budget. So here's something that actually is for you. Amazon is currently giving away $750 gift cards to eligible residents in the US, UK, Canada, and Australia. Completely free to enter, no purchase required. Use it however you need. Stock up on essentials. Grab a few books about what's actually happening in this country right now, or just hold on to it for when things get uncertain. Click the link in the video description to enter. If you're on a bigger screen, open your phone camera, point it at the QR code on screen, and tap the link that pops up. Watching on your phone? Links right there in the description. Takes a minute, it's free, and it's genuinely worth it. Now back to the ruling. Because what Judge Delgado did next is what nobody saw coming. She didn't just issue the warrant and leave enforcement to chance. She designated the enforcement authority directly in the order, page 31. She specified the Federal Marshal Service as the primary enforcement body. She included a compliance timeline, 72 hours. She addressed the Secret Service question head on. And that's where this gets unprecedented. Because the question everyone immediately asks is the same one. How do you actually arrest a sitting president? Here's the constitutional machinery. A federal judge issues a warrant. That warrant goes to the Federal Marshal Service. Marshals are the enforcement arm of the federal judiciary. They execute warrants. That's their job. They do it every single day in every federal district in the country. But this isn't every warrant. This warrant targets a person surrounded 24 hours a day by Secret Service agents whose entire job is preventing exactly this kind of contact. So what happens when federal marshals show up with a judicial warrant and Secret Service is standing between them and the president? Before this week, the answer was theoretical. Constitutional scholars debated it. Law professors wrote papers about it. Nobody actually knew because it had never happened. No sitting president had ever been subject to an active arrest warrant from a federal court. Judge Delgado didn't leave it theoretical. Page 34 of her order directly addresses the Secret Service conflict. She cited the Supremacy Clause. She argued that lawful judicial process supersedes executive protective protocols when the subject of protection is also the subject of a valid federal warrant. She ordered that Secret Service shall not interfere with lawful execution of arrest warrants issued by this court. One sentence. But that sentence did something no federal judge has ever done. It legally compelled the president's own protective detail to stand down for arrest processing. She specified the process. Marshals arrive. Secret Service facilitates rather than obstructs. Processing occurs under joint security protocols. She even designated which federal facility would handle intake. She didn't leave a single question unanswered. Not one. Who enforces? Federal marshals. What about Secret Service? They stand down. Where does processing happen? Designated facility, named in the order. What's the timeline? 72 hours. What happens if the executive branch refuses? Contempt sanctions escalate automatically. This judge didn't just rule. She built the entire enforcement mechanism into the order because she knew nobody else would. She knew that if she left any gap, any ambiguity, any room for interpretation, the White House would drive a truck through it. She'd already watched them do exactly that with the ceasefire, twice. She wasn't going to give them a third chance. The White House response came in two tracks: what they said publicly and what they filed with the court. And those two things told very different stories. Public track first. 4:02 p.m., 44 minutes after Judge Delgado filed the arrest warrant, Trump went on camera, not a written statement from the press secretary, not a carefully worded response from White House counsel. Trump himself, in front of cameras, called the order a disgrace, called Judge Delgado an activist judge with an agenda, said the arrest warrant was unconstitutional and he wouldn't comply under any circumstances. 8 minutes, no notes, no legal framing, pure defiance, broadcast to millions. Now, the legal track. What his lawyers actually filed with the court tells a different story. 5:17 p.m., emergency stay request submitted to the D.C. Circuit Court of Appeals. The filing didn't call the order a disgrace. It didn't attack Judge Delgado by name. It made three specific legal arguments. First, that the original ceasefire injunction exceeded the court's jurisdiction over military operations. Second, that presidential immunity shields the commander-in-chief from arrest for decisions made in his official capacity. Third, that the enforcement mechanism violated separation of powers by compelling Secret Service to stand down. See the gap? On camera, Trump said this was unconstitutional persecution. In the filing, his lawyers conceded the court had some authority, but argued it was applied too broadly. On camera, total defiance. In court, negotiation. On camera, he'll never comply. In the filing, they asked for a stay, which means they're acknowledging the order exists and has legal force. You don't ask a court to pause something you believe has no authority over you. That's the tell. The pattern is identical to every previous escalation. First violation met with a motion to redefine terms. Judge's warning met with a motion to redefine scope. Arrest warrant met with a motion to stay enforcement, not compliance, never compliance. Just new legal arguments for why this particular order doesn't apply to this particular president in this particular situation. And the political dimension cracked open immediately. Senate Majority Leader issued a carefully worded statement at 6:30 p.m. calling for calm and due process. Didn't defend Trump. Didn't condemn him. Said nothing of substance. Three senior Republican senators who publicly supported Trump's ceasefire position 2 weeks ago went completely silent. No statements, no tweets, no appearances. Staff telling reporters their offices had no comment. That silence is louder than anything they could have said. When your allies won't defend you publicly, it means they've seen the filing and they know what's coming. Trump's most vocal congressional supporters did speak, called the arrest warrant a political weapon, called Judge Delgado a partisan operative, but none of them addressed the actual legal question. None of them explained why a president who signed a compliance agreement should be exempt from enforcement when he violated that agreement twice. They attacked the judge, they attacked the process. They never addressed the substance, because the substance is indefensible. He agreed, he violated, people died. That's not a political argument. That's a factual record filed with a federal court. Performance and strategy. Two different things. The performance is for the cameras. The strategy is in the filings. And right now, the filings show a legal team that knows it's losing. Now, Congress. The institution the Constitution actually designed for this exact moment. And right now, it's doing exactly what it always does. Calculating. Within 3 hours of the arrest warrant, 4 House members called for immediate impeachment proceedings, all from the progressive wing. All on record within minutes. Their argument was straightforward. A president who defies a federal court order twice, resulting in civilian deaths, has committed an impeachable offense. Article 2, high crimes and misdemeanors. Defiance of the judiciary. Abuse of military authority. Open and shut. But impeachment doesn't run on arguments. It runs on votes. House needs simple majority. 218 members. Democrats hold 221 seats. Tight. Requires near total party unity. 3 defections and it fails. And right now, at least 7 moderate Democrats from swing districts haven't made any public statement. Their offices are saying they're reviewing the situation. Reviewing. That's the word people use when they're counting votes, not reading filings. Senate is worse. Conviction requires 67 votes, 2/3. Democrats have 51 seats. That means 16 Republican senators would have to vote to convict. Right now, 0 Republican senators have publicly supported impeachment. 0, not 1. The same senators who went silent on the arrest warrant aren't going to vote for removal. Silence isn't courage. It's positioning. They're waiting to see which way the wind blows before they commit to anything. House leadership called an emergency caucus meeting for tomorrow morning. Not an impeachment vote, a meeting. To discuss strategy, to assess options, to calculate political risk. Speaker's office released a statement at 8:45 p.m. saying the situation is grave and requires careful deliberation. Careful deliberation. A president violated a court order. People are dead. A federal judge issued an arrest warrant. And Congress wants to deliberate carefully. The progressive wing is pushing for an immediate floor vote. Their argument is that every hour Congress waits is an hour Trump uses to consolidate defiance and build the narrative that this is political persecution rather than legal accountability. They're right about the timeline. Every day, without congressional action, shifts the story from what Trump did to what the judge did, from violation to overreach, from contempt to controversy. The Republican strategy is already clear. Delay, question the judge's authority, demand hearings about judicial overreach. Shift the conversation from did Trump violate a court order to does a court have the right to arrest a president? Change the subject from the dead civilians to the constitutional question. Make this about process, not substance. Run out the clock until the appeals court rules and hope the stay gets granted so the whole thing goes quiet. Congress is the institution designed for exactly this moment. A president defying courts, an enforcement crisis, a constitutional confrontation. And right now, one side is calculating whether impeachment helps them in November. The other side is calculating whether silence protects them until this blows over. Nobody is calculating what the Constitution actually requires. The courts moved in hours. Congress is scheduling meetings. 3 tracks, all moving, all connected, all reaching critical mass within 72 hours. Track 1, court enforcement. Judge Delgado's 72-hour compliance window opened the moment the warrant was filed at 3:18 p.m. on June 4th. That clock runs out Saturday at 3:18 p.m. If Trump hasn't submitted to arrest processing by that deadline, federal marshals have authorization to execute the warrant. No additional court approval needed, no second hearing. The order is self-executing. Delgado built it that way, deliberately. Key date, tomorrow morning. Trump's legal team filed the emergency stay with the D.C. Circuit at 5:17 p.m. today. The appeals court has to decide whether to pause Delgado's order while they consider the constitutional arguments. If they grant the stay, the 72-hour clock stops. Warrant remains active, but enforcement is paused. If they deny the stay, the clock keeps running, and Saturday becomes the most consequential day in modern constitutional history. Track 2, congressional response. House Leadership Caucus meeting tomorrow at 9 a.m. The progressive wing will push for an immediate impeachment floor vote. Leadership will push for hearings first. If the House moves fast and votes to impeach before Saturday's enforcement deadline, it changes every calculation. Impeachment doesn't remove Trump. Only Senate conviction does that. But an impeachment vote shifts the political ground under every institution involved. Federal marshals enforcing an arrest warrant against an impeached president is a fundamentally different scenario than enforcing against one Congress hasn't acted on. It gives cover. It gives legitimacy. It changes the narrative from rogue judge to institutional consensus. Track 3, executive defiance. What does Trump actually do? 3 scenarios. First, he complies before Saturday, submits to arrest processing, posts bond, gets released. Warrant resolved. Precedent set permanently that courts can compel sitting presidents. His base is furious, but the constitutional crisis ends. Second, he doesn't comply, and the appeals court grants a stay. Clock pauses. Legal fight moves to higher courts. Could take weeks or months. White House claims vindication, but the warrant is still active, just frozen. Third scenario, he doesn't comply, and the appeals court denies the stay. Saturday at 3:18 p.m., federal marshals are authorized to move. Secret Service has been ordered to stand down. And we find out in real time whether the enforcement mechanism actually works against a sitting president of the United States. How they connect. If the appeals court rules first tomorrow morning, it either freezes everything or accelerates everything. A denied stay puts immediate pressure on Congress to act before Saturday. And granted stay gives Congress room to delay, which they will absolutely take. If Congress moves first with impeachment, it strengthens the court's enforcement position and weakens Trump's immunity argument. If Trump moves first by complying, Congress doesn't have to act, and the appeals court question becomes moot. But the precedent still holds. If nobody moves, Saturday arrives, and the system faces the question it's been avoiding since Wednesday. Can a federal court actually enforce an arrest warrant against a sitting president who refuses to comply? This isn't just about Trump. That's what most coverage is missing. Whatever happens in the next 72 hours creates precedent that applies to every president who comes after him. If courts enforce, every future president knows judicial orders are binding, and defiance carries real consequences. If courts fail to enforce, every future president knows court orders are suggestions they can ignore when the political cost of compliance is too high. If Congress impeaches, the legislative check works. If Congress calculates, the legislative check is confirmed as a political tool, not a constitutional one. 72 hours, 3 tracks, 1 question the system has to answer. Does it actually work when a president decides it shouldn't? Here's where we are. A federal judge issued an arrest warrant for a sitting president of the United States. Not over a technicality, not over a procedural dispute. Over dead civilians in Iran in a zone covered by a court order the president agreed to respect and then violated. Twice. The legal record is clear. The ceasefire injunction was binding. Trump's own lawyers signed the compliance agreement. The first strike violated it. The judge warned him. The second strike killed 14 people, including 3 children. The judge issued an arrest warrant. Every step is documented, every filing is on record, every timestamp is in the docket. And now we find out what kind of system we actually have. Not the one we describe in textbooks, not the one we explain to school children. The one that actually exists when it's tested. Either courts can enforce orders against sitting presidents, or they can't. Either the rule of law applies to the most powerful person in the country, or it's just words on paper. Either the system built to prevent exactly this kind of abuse actually functions, or we learn right now that it was always theoretical. I'll be covering every development. When the appeals court rules on the stay, I'll break it down. When Congress meets tomorrow morning, I'll have the analysis. When that 72-hour window opens on Saturday, I'll be here in real time. Subscribe. This is the kind of story where missing one development means missing everything that follows. Every piece connects. Every hour matters. And don't forget that free $750 Amazon gift card is still available. Links in the description. Free to enter. Go grab it before it's gone.